In the second panel discussion, we'll move from the commercial world to the construction world. We have our speakers and moderator on stage. We have Joanne Lau, Secretary General of HKIAC, Ian Pennicott, KCSC, Kelvin Chuck, and Jonathan Chan of DVC. We have Kaiser Leung as our moderator.
Thank you, Sabrina. Welcome everyone to the second panel discussion of the day. As Sabrina has mentioned, this session will be focused on a construction law practice dispute area. And the topic is fundamental change to the landscape of construction disputes, the introduction of security of payment legislation. For those of you who practice construction law in Hong Kong would have heard of the imminent enactment of the security of payment legislation. After all, the discussion on the potential introduction of the legislation has been ongoing for many years. As early as 2011, the government and the Construction Industry Council conducted an industry-wide survey, and it was found that unfair payment terms, payment delay and disputes were causing widespread cash flow problems affecting contractors, subcontractors, suppliers, and consultants. A few years later, in 2015, a public consultation was conducted on the proposed security of payment legislation. The government formulated a security of payment framework and its scope of application for the drafting of the intended bill. But not much has happened in the few years that follow until 2021, when the government issued a technical circular introducing a contractual scheme and promulgating the implementation of the spirit of the security of payment legislation in new public works contract from December 2021 onwards, with a view to facilitate a smooth introduction of the legislation through the experience gained in public works contract. Now, the latest news that we have is that the legislation will finally be enacted in the later part of this year. Now, those who aren't construction law practitioners would ask, what is the big deal with this proposed legislation? Why has the government taken so many years to proceed with the legislation? What is so fundamental about this proposed legislation, and how is it relevant to arbitration? Now, as will be further discussed later this morning, the spirit of a security of payment scheme is to facilitate timely processing of contract payments and the introduction of an interim mechanism for speedy resolution of payment disputes under construction contracts through a dispute resolution mechanism known as adjudication. In short, adjudication is a dispute resolution mechanism whereby a dispute would be referred to an adjudicator who will consider and decide on the dispute with a written decision stating the amount to be paid. The timetable for such mechanism is short, and the costs are low compared to arbitration and court proceedings. If either party is unhappy with the adjudication result, they can take the dispute to court or arbitration for a final determination in the usual way. This would not be an appeal of the adjudicator's decision, but a fresh consideration of the dispute. However, it is important to note that the adjudicator's decision is still binding and enforceable on an interim basis unless and until the payment dispute is determined otherwise by court or arbitral tribunal. The adjudication regime is designed in part to address the cash flow problem in the construction industry. Adjudication decisions are intended to be dealt with swiftly, and there would be an element of rough justice in the pursuit of a speedy and economic resolution. And the approach has been summarized and described in past cases by the mantra of pay now, argue later. Now, I hope that gives you a flavor of the dispute, of the topic and issues that will be covered this morning. And with those introductory remarks, if I may now pass the floor to Ian, who will give us an overview of the security of payment legislation.
Largely because I want to keep myself awake, I decided to stand up in the hope I shall also keep you awake in what I have to say. What we're going to do is really deal with this in 4 parts. I'm going to give a brief overview, which is putting a little bit of flesh on the bones of the matters that Kaiser has already mentioned. Calvin is then going to talk about the time frames in relation to payment disputes and adjudication. Then Joanne, as you've heard, the Secretary General from the HKIAC, is going to talk to us about adjudicator nominating bodies, of which the HKIAC is going to be one. And she's got various topics that I think are of great interest, because at the bottom line, it seems to me, with this process is parties are going to want to know how they're going to get a competent, independent, impartial, efficient adjudicator. And it's those sorts of questions, seems to me, that aren't really answered at the moment from what we know. And then fourthly, I'm going to return with Jonathan to look at questions of enforcement of adjudicators' decisions and also look at some statistics that we've obtained from the UK in an attempt to analyse what impact this adjudication process may have on arbitration in Hong Kong. Now, I should start perhaps by issuing a disclaimer that the heading or topic of this day, this event, is shaping the future of international arbitration. Well, it seems to me that the word international in this context is not quite apt, because what this legislation is going to do is affect domestic arbitration in Hong Kong. That said, of course, foreign contractors, non-Hong Kong contractors, whether they're from the mainland, from Japan, Korea, France, Germany, operating in Hong Kong, will be caught by this legislation if the project that they're dealing with is Hong Kong, is based in Hong Kong. As Kaiser has already indicated, the underlying reason for this legislation is the unsatisfactory and deep-rooted payment and cash flow problems faced by the supply chain in the construction industry in Hong Kong. And if one thinks of a typical structure of a building contract or a construction contract, one has an owner or an employer who wants to develop a project. He engages some consultants to design his project. He then engages a main contractor to build his project. That main contractor will engage subcontractors to deal with specialist works such as piling, perhaps cladding the buildings, electrical works, plumbing and drainage works. These are all the specialist subcontractors. Those subcontractors may engage further subcontractors down the line. And all of these people, all of these contracts are all going to be caught by this legislation. The Act will, we think, split the contracts into 2 effectively. There'll be the public works contracts, and then there'll be the private contracts. Public works contracts will be defined in the sense that it will be the government, and there will be a list of other public or quasi-public bodies. So the universities, the MTRC, the Hospital Authority, the Housing Authority, all of these will be regarded as public bodies and public contracts. As I understand it, there will be no value of those public works contracts. Any value will be caught by the legislation. In the private sector, it's slightly different. There will be a financial limit I think it's going to be set at 5 million. You've got to get over 5 million before you're caught by the legislation. There may be a lower threshold for a subcontract. But all of these, say, parties will be caught by the legislation. Not only the people I've mentioned, but also suppliers to construction projects are also going to be caught by the legislation. So if you're supplying plant and equipment to a project, you'll be caught. If you're supplying materials, you'll be caught. So all of this is quite important across the construction field in Hong Kong. The principal proposals in the legislation are likely to be threefold. One, improving, if not indeed imposing, certain contractual terms into contracts. There must be, the contracts must include certain provisions in relation to payment. And Calvin will be talking about that a bit later. Secondly, as we've heard, introducing a mechanism for a speedy resolution on an interim basis of a payment dispute. And thirdly, and it's not a matter we can go into today because it's just too complicated, in certain circumstances, the legislation will empower contractors and subcontractors to suspend or reduce the rate of progress of work in specific defined circumstances. And so, as I say, that is, as it were, its own topic, and it's not something we'll look at, I think, today. As Kaiser mentioned, there has been in existence since 2021, a Development Bureau technical circular, and the government's had a dry run in a number of its Development Bureau projects of the adjudication system. Who knows what's happened? If there's anyone in the room that could tell us how that process has gone over the last 3 or 4 years, I think we'd all be interested to know. Were there any adjudications? If so, what happened? I mean, we just don't know. All we know is that the government has decided to press ahead with this piece of legislation. And as Kaiser mentioned, it is now relatively imminent. As Kaiser mentioned, it is before LegCo at the moment. It is likely that it will be gazetted in either the 3rd or 4th quarter of this year, and then there'll be a 1-year period when it actually comes into effect. So one's looking at the tail end of 2025 before it is in place. As we'll be looking at a little later, albeit in not a great deal of detail, the equivalent provisions have been in operation in the UK since about 1996, introduced into other jurisdictions over time, including in Australia, although it's individual states that have introduced the legislation in Australia. New Zealand, Singapore, Malaysia, Canada have all got equivalent provisions in their legislation. The relevant provisions in the legislation in those various jurisdictions is not identical by any means. It's unlikely that our ordinance is going to be the same as any of the other ordinances. One is rather hoping that the delay that has occurred in bringing in this legislation, again, which Kaiser touched on a moment ago, is actually going to benefit us in the long term in the sense that some of the less successful aspects of payment disputes and adjudication in these other jurisdictions will not be enacted here, and we'll have taken the best bits and got rid of the worst bits. So better late than never, perhaps, may produce some improvements and benefits to Hong Kong. Anyway, the cornerstone of the SPOL, as I think we're all going to call it, is the right of a party who believes he is owed payment by another party with whom he has a contract, and that falls into the definition of construction contract, to refer that payment to a dispute mechanism called adjudication. Whilst it is unlikely that the adjudication process will be as fast as it is in the UK, brackets 28 days from the commencement of the process, and it won't be as fast track as that, nonetheless, it is going to be a fairly fast process, which, as Kaiser mentioned, will have interim binding effect. In summary, the paying party, pursuant to an adjudicator's decision, is going to be required to pay up, but is not precluded from subsequently taking the dispute to arbitration or litigation. In the last section that Jonathan and I will be talking about, dealing with later, we've looked at some statistics in the UK just to see how likely it is, if you have an adjudication, you will then follow it up by having an arbitration or a piece of litigation. And we'll tell you what we think the answer is going to be later to that. So anyway, with those words of introduction, I'll hand over, I think, either to Kaiser or to Kelvin.
Very insightful overview. Now, perhaps we can move on to a more operational level of the proposed legislation. Kelvin, can you tell us more about the expected structure of the proposed legislation? Now, obviously, we haven't seen the legislation itself, but can you tell us what can be expected in terms of procedure and time frame, etc.?
Thank you, Kaiser. Let me start by answering this question by giving the audience 4 numbers: 30, 28, 5, and 55. These are not the numbers for your horse racing nights. Okay. But I know some of our participants are not practicing construction law, and it might be helpful to give you these 4 numbers to summarize the timeline and the time flow regarding adjudication. Let's suppose we are building a stadium, and of course, the main contractor will driving their piles into the ground. Let's suppose in this month, from today, they have driven like 10 piles into the ground. So by the end of the month, i.e. 31st of May, under the legislation, they will have an entitlement, statutory entitlement, not contractual, to make a payment claim against the employer. So now we have the first number kick in, 30 days. After the employer receives this payment claim, the claim, by the way, has to be in writing. It has to identify the construction work, and it has to state the amount it claims. After the employer receives this payment claim, then it has to decide to make a payment response. The payment response, again, has to be in writing, has to identify the payment claim, and has to state what amounts it agrees and what amounts it disagrees. So if the payment claim is not wholly accepted, or in the case where an employer chooses not to serve any payment response at all, then a dispute will be deemed to arise from that point. And now we have the second number, 28 days. The 28 days is counting from the dispute to the time where the contractor can serve a notice of adjudication. The notice of adjudication will be served on what we call A and B's, adjudicator nominating bodies. Currently, we had 4 A and B's. The first is HKIA, Hong Kong Institute of Architects, HKIS, Hong Kong Institute of Surveyors, HKIE, Hong Kong Institute of Engineers, and lastly, and probably I would think the most important one, HKIAC, And we are very pleased here to have Joanna here today to share with her thoughts into the process. As you might have heard, the whole process, although the government call it a public consultation, not much is disclosed to the public. And it's good for Joanna here to share with us some inside thoughts. One important point I would wish to emphasize here is that if the employer chooses not to serve any payment response, that doesn't mean he or she cannot participate in the adjudication process. What that means is that he will put the contractor into strict proof of everything in that payment claim. However, the employer will be prevented from raising any counterclaim or set off. The rationale is simple, to prevent any surprise, because the adjudication process, as you will continue to find out, is very short and swift. They don't want any surprise raising only during the adjudication process, but not before the commencement of the adjudication. After the contractor serves its notice of adjudication, the third number will kick in, the 5 days. Now the responsibility falls onto HKIC or other AMBs to nominate an appropriate adjudicator within 5, they call working days. The previous was calendar days. Now we have 5 working days. Of course, that will be a rather challenging task. How HKIC and other AMBs can nominate an appropriate adjudicator within such a short period of time is not easy. Now suppose we have got appointment. Now we will get to the 4th number, 55 working days. That counts from the appointment of adjudicator to the publication of the adjudication decision. So it's a very short period. The claimant is required to serve its submission together with all the supporting documents within 1 working day after the appointment of adjudicator. The short period of time presumes that they know their case, because it's them who start the adjudication process. And then the respondent side will have 20 working days afterwards to serve their responsive submissions and all the supporting documents. The remaining period will be left for the adjudicator to manage. They might call a hearing, or they might simply decide the payment claim on the basis of paper. The adjudicator might extend the time, but he or she should not extend it substantially, because that will defeat the whole purpose of adjudication. Okay, now let us put this into a proper context. Let us suppose you're building a stadium, and in May, a contractor incurs like 50 million. That's a month. That's a very reasonable assumption. So if in a normal court litigation proceedings, from writ to judgment, we are talking about at least several years, 3 or 4 years. But within the adjudication scheme, the decision from adjudication to the end, or even from the payment claim to the end, we're talking about two months. That is the speed required or changed under what we call this new era. I think that's what I wish to explain to you.
Thank you, Kelvin. How about the scope of application of this secure payment legislation, which Ian briefly touched upon earlier, and also the scope of disputes that is to be covered by this secure payment legislation as compared to the experiences from the other jurisdiction?
I think Ian has briefly touched on. For private contracts, there's a limit of around 5 million. So only the contract sum of private contracts above 5 million will be caught by the legislation. I think the reason is that during the consultation period, some small contractors expressed concern because they don't know the adjudication scheme, they don't have resources to deal with adjudication. So that was taken into account into the final proposal, and that was excluded from the legislation. But we come to a very critical difference, at least between the Hong Kong scheme and the UK scheme. In the UK, basically you can adjudicate almost any kind of disputes, like from if you want some more time, you want some more money, and from I heard from Ian, you can actually adjudicate a negligence claim. But in Hong Kong, the scheme is much more limited. In Hong Kong, the applicable scope is limited to what we call payment claims, i.e. only monetary claims can be adjudicated under the Hong Kong scheme. So if, let's say, going back to our example, there was a delay by the contractor or by the employer in the stadium construction, and the contractor wishes to claim prolongation costs and extension of time. To the extent that extension of time can be subsumed under the prolongation cost claim, that can be advanced under the current scheme. But what is not permitted is a freestanding extension of time claim, which is allowed in the UK but not allowed in the Hong Kong scheme. Another important difference between Hong Kong scheme and the UK scheme is that in the UK scheme, it's a two-way street. Basically, the employer can claim against the contractor, and the contractor can claim adjudication against the employer. But in Hong Kong, the street is one way only. So only the downward party can make an adjudication against the upward party. But the upward party cannot launch an adjudication against the downward party. The reason is that they suppose the money is being withheld by the upward party. So to facilitate or to resolve the cash flow problem, the really issue is to facilitate the payment from the upward party to the downward party. So I know there's a lot of rivalry between Hong Kong and Singapore, but let me just end up in my answer from a quote from the Chief Justice of Singapore. In Civil Tech and Hua Rong's engineering, Men and CJ said, the Singapore Act was not intended to provide upstream parties with an avenue to bring claims against downstream parties. Importantly, where a payment dispute arises, the upstream party does not generally require recourse because the money is in its pocket. It can simply withhold payment, asserting a set-off or cross-claim as the basis for doing so. The upstream party will generally have the means of protecting its position pending the determination of the payment disputes, whereas the downstream party will not. The Act seeks to temper this asymmetry. I think that's what I wish to say.
Thank you. Ian, do you wish to top up on that?
If there's any time left. Keep getting these signals from the back. Okay. 5 minutes left, 1 minute left. But all I was going to add to that, and it may be it's connected with the 5 million limit and the 500,000 that we've touched on. In the UK regime, as Kelvin has said, for example, claims for damages under a construction contract are perfectly, can be referred to adjudication, no problem at all. That will not be permitted here. We are talking about payment claims under the contract, not claims for breach of contract. So that's an important point. And secondly, in the UK, which I think is going to be mirrored here, there's what's known as the residential occupier exclusion. That is, if you have some work done to your apartment, your private residence and so forth, that will be taken outside of the legislation as I understand it. And of course the logic of that is that you wouldn't expect your average owner-occupier of an apartment in Hong Kong to know anything about the security of payment legislation, and the same logic applies in the UK. So I think there will be that exception enacted into our legislation as well.
Thank you, Ian. Thank you, Kelvin. Now we move on to the next topic, which both Kelvin and Ian have touched upon, and that is a very important issue of adjudicator nominating body. And now I'll turn to Joanne. Now, what we know from the security of payment framework is that a register comprising of organizations that will be authorized to perform the duties and function of an adjudicator nominating body will be established and maintained by the Development Bureau. And we also understand from the technical circular for the implementation of the contractual scheme in public works contract, a simplified mechanism has been introduced for the nomination and appointment of adjudicator by an agreed A and B from the register as specified in the contract. And we know that HKIAC, as Kelvin has mentioned earlier, is one of the 4 A and Bs in the register. And the register is obviously a very important thing because under the contractual scheme, an employer would not entertain any request for direct payment of unpaid adjudicated amount if the decision is made by an adjudicator not appointed by an A and B on the register. Now, looking forward, what measure has HKIAC put in place in preparation of its role as an A and B under the proposed legislation?
Thank you for the question, and it's a pleasure to be here. Perhaps before I delve into the question of the role of, I'll call it A and B, adjudicator nominating body, before I go into details, let me just say by way of background, when I was in private practice, I wasn't a construction arbitration lawyer, but since I've taken on this role and learned about the SOPL, I'm actually feeling very excited about it, and I can totally see the potential of changing the landscape, because I think what might potentially happen is right now there are a lot of disputes which may be accumulating, and then by the end of the project, people would have a dragged out construction arbitration. When SOPL comes out, possibly there will be maybe smaller disputes, but a lot more frequent disputes and a much higher volume of adjudication. So I think that has the potential of really changing the landscape. So that's why I think it's very important for HKIAC to be prepared for this potential change in landscape. We're waiting to see the finalized bill, and we've been having lots of discussions with the Development Bureau and the other A and Bs to work out the specifics. So there may be a limit to how much I can share, but I do want to share some color and also to draw on our experience in appointing arbitrators, and also to draw on our experience in relation to the security of payments for public work. So even though we haven't seen very much coming out of it yet, I think it's still a very positive thing that it happened 2 years ago, because it gave us an opportunity to develop like adjudication rules, develop a panel, which would all provide us with insights and experience on how to implement this when this all comes into effect. So briefly, what the A and B's role would be. First of all, as you all mentioned, establishing and maintaining a panel of adjudicators. That may be the most important role of all. And in putting out adjudicators on that panel, running training programs, developing training programs, potentially with organizations like CIR, to make sure that people who are on the panel are qualified to handle those adjudication. That's the second point. Third one is to develop a mechanism for appointment of adjudicators, and I'm glad that it has been changed from 5 calendar days to 5 working days. But I must say, like hearing the previous panel on emergency arbitrators, we do have experience of having to appoint someone to adjudicate a dispute very quickly. So even though 5 working days is a compressed timeline compared to how we appoint arbitrators, that is doable. And finally, establish a set of adjudication rules for the adjudication proceedings to abide by. So I expect when the bill comes out, there will be some framework, but each A and B would also have to develop some supplemental adjudication rules to add on to what's in the framework. And I think similar to what we've done for security of payments for public works, there may also have to be other supplemental papers such as code of conduct for adjudicators or some practice notes to provide guidance to adjudicators. So maybe I'll leave it at that, but happy to take questions or
I guess I have one follow-up question, and I think it's probably quite a practical question from practitioners, and that is if parties are dissatisfied by the performance of a particular adjudicator, will there be a mechanism where HKIC can address those complaints?
Yeah, I think that this is a good point because we've heard a lot when discussing this scheme. We talk about like rough justice. We talk about how this is supposed to be like quick and dirty. But at the end of the day, I think the basic quality, the essentials of dispute resolution, the quality needs to be guaranteed because otherwise people would lose faith in it and it would lose legitimacy. So even though it's a compressed timeline, first of all, on quality control, there are things which, as an A and B, we cannot cut corners. So for example, checking conflicts of interest, that's really important. Panel of adjudicators, we need to make sure they are qualified and properly trained before they can be appointed to the panel. That's also essential. And specifically in terms of complaints procedure, I expect there will be a mechanism in place similar to, say, arbitrators for us to handle complaints when they come up. So say, for example, in appointment of arbitrators or in security of payments for public works, we rely on our external appointments committee to look at and deal with these complaints. So I'm sure there will be similar quality control arrangements in place.
Thank you. Any follow-up comment?
Can I just ask a question, Joanne? Is it envisaged, do you think, that the ANBs, HKIC and the others, is going to have some control over the fees of adjudicators, or how's the fee situation going to work for the adjudicator?
That is a hot topic. I'm not sure how much detail we have now. It's still being discussed. But I think when it comes to fees of adjudicators, and again, drawing from the experience from the public works regime, there will be two important factors to take into account. One would be the claim amount, and the second one would be stating the obvious, the experience of the adjudicator. And by experience, it would likely be by reference to, say, the PQE, if it's a legal professional, or years of experience in dealing with construction disputes.
And perhaps another question, and this perhaps is a bit unfair. You may not know the answer, but my understanding is, and I know there are one or two other UK lawyers here, that in the UK you are permitted to name your adjudicator in your contract, and you can have an adjudicator and then a substitute adjudicator and then a default position you go to the ANB. Is it envisaged that that will be permitted in Hong Kong, or is going to an ANB going to be compulsory?
That I do not know for sure, and I think we need to see what's in the bill, but just thinking out loud, given for all the panels, we need to ensure that adjudicators are properly trained and qualified. I do wonder if parties specify an individual as adjudicator, whether that person needs to at least, for example, be on one of the panels of adjudicators, just to have some more quality assurance. But we'll see in the bill.
That's an interesting thought. I hadn't thought about that. Not just name your adjudicator, but if you pick somebody off the list, that might be a different position, perhaps. Yeah, well, as you say, we'll have to see what the what the bill says.
Thank you. Thank you, Joanne, for that information. Now, in the final part, I would like to go back to Ian and Jonathan on this. Now, we know that the United Kingdom pioneered in the security of payment legislation, which was followed by a number of jurisdictions, including Australia, New Zealand, Singapore, and now Hong Kong. Now, obviously, there are some major differences in terms of the structure and the contents of the legislation in the UK regime and the Hong Kong proposed regime. But can you tell us about the UK experience in terms of enforcement? Because one can foresee that that will generate a lot of disputes arising from the enforcement of adjudication.
Let me start, and I'll sit down this time rather than stand up. Enforcement in the UK, and we'll come to some statistics in a moment, but essentially the procedure for enforcement in the UK is to go to the Technology and Construction Court, which is a specialist division of the Commercial Court in London. And they have their own set procedure for enforcing adjudication decisions. And it's a rapid procedure. And you would expect the court to determine any issues on enforcement within a matter of a few weeks, possibly shorter than that. What is going to happen here, we're not entirely sure. If an adjudication, if a party successfully obtains a monetary award in its favour, but the paying party still fails or refuses to pay up. What I think, reading between the lines of the technical circular and other documents that are available, is that a party is going to have a statutory right to make an enforcement application to the court, that is the court of first instance of the High Court. And the inference appears to be that the adjudicator's decision will be treated as if it is a judgment of the court and will be enforced in the same manner as a judgment. No doubt the legislation will set out certain procedural requirements for a court application, but the key question is how quickly is it going to be before you get that enforcement decision. Regrettably, as I think William mentioned this morning, the Hong Kong courts are overburdened as it is at the moment. It takes a long time to get trials on. It takes a long time to get applications on. And of course, if that is going to apply to adjudicators' decisions, then on one view, the whole purpose of this legislation is going to be undermined. So I'm hopeful, but obviously we will need to see the terms of the bill in all its glory in due course. But I'm hopeful that there will be something in the bill which will provide for a rapid result, a matter of a week or 14 days or something. As I say, because if that doesn't happen, then it's all going to be a bit of a damp squib. I would add that the corollary to enforcement is that I understand that an unsuccessful party, the paying party, will also have a right, a limited right, to apply to have the adjudicator's decision set aside. Now, limited in the sense that I understand the legislation is likely to give 3 grounds for having a decision set aside. That is the usual one, fraud or bribery in the process. Secondly, a breach of natural justice, which is a fairly wide and loose concept. And thirdly, jurisdiction. At least the adjudicator has gone outside what he's been asked to decide. So that's the broad points. And then could I just ask Jonathan quickly to mention a few points about the statistics we've been looking at, and then I'll just wrap up by saying a few words about the likely impact that this is going to have on arbitration in Hong Kong.
Yes, Ian and I have been looking at some statistics in the UK to try to assess the possible impact of the SOPL, the legislation. We've considered the latest report on construction adjudication in the UK published by King's College London and the Adjudication Society, published in November last year. The objective of this report is to publish empirical analysis in order to take stock of how adjudication is currently functioning in the UK. We have extracted from this report 6 key findings which may show the landscape and performance of the scheme in the UK. First of all, the number of adjudication referrals has been on an upward trend since the introduction of statutory adjudication in the UK in 1998. During the first year, there were less than 200 referrals, but the number increased to around 1,500 in around 2010, and further increased to around 2,000 in 2023. Secondly, somewhere between 70 to 80% of adjudications involve an appointment by an ANB, an adjudicator nominating body. Thirdly, the default period under the UK scheme of 28 days from the date of referral notice to the date of decision appears to be too short, since only 12% of adjudications were completed within 28 days, and the majority of adjudications lasted between 29 to 42 days. Fourthly, the number of formal complaints is very low. Between May 2022 and April 2023, there were over 2,000 adjudication referrals, but only 22 complaints. And out of those 22 complaints, only 2 complaints were upheld. And the principal grounds of challenge include breach of natural justice, overcharging, undisclosed conflicts of interest, and lack of expertise relevant to the dispute. Fifthly, the statistics show that it is rare for adjudicated disputes to proceed to litigation or arbitration, as 25% of the research participants said that they have never seen an adjudicated dispute refer to arbitration or litigation. And overall, the number of referrals to arbitration or litigation is below 5% of the total number of adjudication referrals. So in most of the cases, the parties were satisfied with the adjudicator's decision and decided not to proceed further to arbitration or litigation. And the last one is that the statistics show that attempts to resist enforcement are very low as a percentage of adjudication referrals. For the period between October 2011 and April 2023, the figure is just over 1%, based on around 20,000 referrals and around 200 judgments rendered by the UK Technology and Construction Court. Perhaps I will pass it back to Ian to give us some insights.
Just a final remark from me, given the time. It seems to me that looking at the question of the impact that all this is going to have on construction arbitration in Hong Kong, the key statistic from what we've looked at is the rarity of a subsequent reference to arbitration or litigation when you've had an adjudication. Now, there could be many reasons for that. It may be that parties are just prepared to live with the decision, even if they don't necessarily agree with it. It may be that psychologically parties have had a dispute determined by an independent, impartial individual, and they think they've had their day in court, if you like, and they don't really want to go through it again. Thirdly, they've expended money in having that decision determined, and they don't want to rehash the dispute by going to arbitration and so forth. There may be other reasons as well. But it does seem to me that based on that statistic, the likelihood is that there will be a significant drop in construction arbitrations in Hong Kong. I mean, one has to, of course, treat the statistics in the UK with a degree of caution, because as we've heard, the scope of the disputes in the UK is much wider than what's going to be permitted here, that is the payment disputes. So in a sense, one may not be quite comparing apples with apples, but I still feel that if payment disputes are going to be resolved by adjudication, it's going to be pretty infrequent that they will then be challenged again in arbitration or litigation. And probably, not all lawyers may agree, that's probably no bad thing. Can I just conclude this by quoting from a book by Lord Justice Coulson, who has written the textbook on adjudication, construction adjudication in the UK. It runs for about 500 pages. There are over 500 reported decisions of the TCC court on adjudication enforcement. And it's got its own sort of jurisprudence that's built up in the UK over the last 30-odd years. And he says in his author's note to the 4th edition, which he says is going to be the last edition, I remain firmly of the view that adjudication is an extremely effective and cost-efficient method of dispute resolution, which has permanently altered the construction law landscape, and very much for the better. I hope that perhaps in a few years' time, somebody will be able to say the same thing about adjudication in Hong Kong.
Thank you, Ian and Jonathan. If I may just make a few very final concluding remarks, it won't take long. After years since its initial study, consultation, and contractual pilot scheme, the security of payment legislation is finally being introduced in Hong Kong. Now, of course, one can foresee that there will be a fundamental change in the landscape of construction dispute in Hong Kong, in that the main battlegrounds between the parties may be shifted from arbitration to adjudication because the parties might not have the appetite to re-argue everything in arbitration. Now, of course, as Ian has touched on, given the limited scope of the dispute that is referable to arbitration under the Hong Kong scheme, the impact might not be as extensive as we see in the UK. Now, notwithstanding the lessons learned from the other security of payment legislation jurisdiction, it can be expected that there remain legal issues arising from the Hong Kong scheme to be ironed out. But we can be confident that the court and the practitioners will resolve these issues, and that the Hong Kong scheme will become more mature and efficient over time. We very much look forward to the implementation of the security of payment legislation, which is expected to bring positive changes to the construction industry in Hong Kong. We hope this has been informative and interesting to you. Thank you everyone for attending today's conference. Many thanks to our speakers. Special thanks to our guest speaker, Joanne, for taking the time to join our panel discussion. And I now conclude the session. Thank you.